Thank you. Thank you very much. And thank you for the questions, ladies and gentlemen of the media, because it's important that we clarify one another on these matters. There's a question here which was raised, which was whether the statement by the CJ was to be expected, our reaction to it. And the answer is yes, of course, we were shocked. We did not expect it. That's the truth of the matter. There hadn't been some prior consultation as to what would come out of a lecture, if it was a memorial lecture by the CJ. Of course, the Parliament, of course, is subjected to public scrutiny all the time. However, the one reason why we decided that we should have an engagement with the CJ is that there's a difference between what you write, what you say, and what any other South African says about Parliament or about an arm of the state, which is the legislature. But it's something else when a head of an arm of the state, of that institution, the judiciary, raises a matter in the public arena about another arm of the state. You get my point? So it's not so much that you are beyond, as Parliament, we are beyond reproach. We do not want criticism. No. It is about a head of the judiciary, the Chief Justice of the Republic of South Africa, takes the floor and raises issues which he has never raised with the presiding officers of Parliament. Now, the state is made of 3 arms. South Africa is a constitutional democracy. We have these 3 arms of the state which collaborate, which cooperate, but once you pick up something that is likely to cause and give a picture to the South African public that there is no stability in the state, because when that happens, it creates amongst yourselves and everybody an impression that these people are not talking. What's happening? These ones are undermining that one. What is this now? Is this the democracy we have? We have a stable democracy. And part of its foundations should be regular interactions between the heads of the 3 arms of the state. So when that statement came out, and of course there was reaction to the statement, but you must have observed that from the side of the presiding officer, the executive authority of Parliament, we did not respond. Deliberately so. Because it can't be us who, in a public domain, in the streets, responding to a matter raised by the Chief Justice. We had a quick consultation and we said, we're not going to respond to this. At best, so that we needed to understand the context within which his remarks were made. So we had this interaction with the Chief Justice, and indeed, we do have an appreciation of the context within which the remarks were made. So sometimes so the answer is what I've said. It was a yes. I mean, we're shocked because the immediate thing the chairperson asked was, did you receive any request for a meeting? Is there something we are missing? And we asked the secretaries, STP, is there something we are missing? Is there something we've not done right? And we could not get it, and therefore, hence the need for clarity, but also to explore issues, to engage amongst ourselves so that we have an understanding. You can never have 3 arms of the state which do not work or collaborate with one another. So the essence of what we were trying to do there was to say, CJ, you've raised your issues. Let us understand the context within which you raised the issues. Allow me to go to that context because it has been raised by the SAPC. CJ says, Speaker Chairperson, there have been several motions of no confidence moved in Parliament against a head of state. Then he goes back and says, if I recall, there were 8 motions which were moved against a sitting head of state then. Okay? This was, remember, this was prior to the State Capture Commission. And so we listened, and he said those motions of no confidence could not succeed because of the majority of members of Parliament who belong to a particular party. Obviously, colleagues, this is a democracy. It's a multi-party. We have 14 parties in Parliament. So our response to that was, you are correct. And we actually know who he was referring to, which party he was referring to. But we said, CJ, you cannot then put it at the doorstep of Parliament and say Parliament has not followed its processes. And then we went on to say, following your report, actually, if you look at Section 89 of the Constitution, which talks about a removal of a head of state, right? Following this commission, Parliament had to sit after 2018 and look and devise a rule, formulate a rule that would be used in the event there were to be this kind of situation we were confronted with at the time. That was done. We formulated the piece of the rule. And of course, following that, subsequently, this year or last year, there was another motion against a sitting president. And what did we do, colleagues? We went back to the rules which we had drawn after that experience of the 8 motions which the judge was referring to. And we reminded him that you can't say Parliament did nothing. We actually formulated this particular rule, which rules leads towards an impeachment of a head of state. However, there are certain things which must happen first. That is, one, you must have a substantive motion against the head of state. And once you have a substantive motion against the head of state, then Parliament puts together a panel. And that panel is the one which we had put together, which all of you are aware of, which was chaired by former Chief Justice Ngobo. And the Chief Justice Ngobo and his team worked behind the scenes. They did their work, and they presented a report to Parliament. Parliament did not hide the report. It was a transparent process. We gave you the report, and the report was tabled before the House of Assembly. And having tabled the report before the House, then the House voted on the report. The House voted on the report. And of course then, having voted on the report, the majority voted against the report. What is my point? My point is that you can't say nothing has been done by Parliament. We here, as the EAs, our conscience is very clear that we did everything to the latter, everything relevant to this section of our Constitution. Now, I then said to CJ, maybe CJ, as we conduct, as we do civic education, memorial lectures, and so on, the emphasis actually should be on political parties and civil society, that when you send your representatives to Parliament, at some point they'll be confronted with A, B, C, D, and E. But you can't, because the report was voted against by the majority in Parliament, you can't then say Parliament failed in its execution of its task. Ours as Parliament was to ensure that we put together systems that will do what is desirable, and if we don't win then, having done that, it is not us, it is the political parties which are sitting in Parliament. Then, of course, the CJ raised the matter of the majority. It's out of our hands, that one. There's majoritarian rule in South Africa. It's a democracy. It's absolutely nothing. It has nothing to do with us. So to raise an issue around the majority, that the majority exercised its majority, has nothing to do with the presiding officers of Parliament and has nothing to do with the processes of Parliament. Majority used its majority. And this is what we explained to the CJ. And I think he understood that. Now, you're asking whether he withdrew the remarks. Of course he wouldn't withdraw the remarks because he believes what he said is correct. But of course he had to understand, that is why we ended up with a discussion on majoritarian, democracy, and the rules of Parliament. That we have rules, we have everything, we have processes, and this is what we have been doing. We've followed because we've learned from our past experiences. So an impression should not be created that Parliament has not learned from its previous experiences. No, no. Now, the chairperson have responded to the issue of the Electoral Amendment Act. You know, I just want to, and I think these are some of the things the media should also be picking on. This is politics. There's something called politics. There's something called the law. Sometimes it can be very dangerous to venture into an area of politics because you end up being entangled in debates by politicians. And once you get entangled in debates and positions of politicians, you may actually find it difficult at the end of the day to adjudicate when there is a crisis amongst ourselves. I'm raising this because this Electoral Amendment Act is ready. But we know that right now it has been taken on review to the Constitutional Court because there are groupings which are unhappy with it. You see now, that's a tricky one. Because once you've commented on that Electoral Amendment Act and expressed your views, it makes it difficult tomorrow when this matter is presented before you to adjudicate on the matter. Because then we remind you that, but by the way, you have views on this matter and you've commented on the matter. So those are some of the, and I think that the spirit of the meeting which we had with the CJ was such, and I think he understood some of the issues we raised. There was no disagreement whatsoever. The other thing we emphasized, by the way, is that in the report itself, there is nowhere where it is stated that it is expected that we report back to the chief, the CJ as head of the commission about progress made in our work. Nowhere. There is nowhere. If we had a clause that says we have to go back and report, maybe we would have done that. So he wouldn't have known what work is being done in Parliament until such time he himself asks for information from those who are deployed to Parliament. Now, my brother from ENCA, you are saying we are literally rejecting the majority of the recommendations. No, actually. It's the opposite. And if you, or I think they'll give you a matrix which we are using. There's no truth to it, but what is happening is that you find that most of the recommendations are actually talking to what we are currently doing anyway. But what needs to be done is to enhance the manner in which we exercise or we implement the rules. So a lot of what came out here in the report are things which are there in the rules. Those who were there drafting the Constitution, I guess, and the rules, had the foresight to appreciate that we may get to a point where we'll have these kinds of challenges. However, it is the speed with which we do things at times and how we do things. Not that it is not accommodated for in the rules. So if you look at that is why we're saying, in terms of the work, which recommendations which came to us, a lot has been done. And allow me to get to the issue of because we know we have a constitutional obligation to do these things anyway. Allow me to go to the issue of the Oversight Committee, because it has been raised over the presidency. You know, what we did here is we requested our research team to do some work, just to do a desktop analysis of where this thing is, where we can find it, and what it is that we do. The report was presented to us. And when the report was presented to us, we found that, in fact, we don't have this animal called Oversight over Vote 1. But rather what we have in India, for instance, you have an overarching committee which monitors across the board. And then in Britain, you have what is called a liaison subcommittee, which liaison subcommittee has a responsibility to engage with the Prime Minister. So thrice a year, the Prime Minister appears before the liaison committee, and we are not even clear what kinds of issues are discussed between the liaison subcommittee and the Office of the Prime Minister. So after a long debate amongst ourselves in Parliament about whether to have an oversight committee or not, we decided, okay, let's have a small group from the Rules Committee, which is called the Review Subcommittee, to go to Britain and make sure that their visit coincides with the appearance of the Prime Minister before the subcommittee. And that's what we are currently doing. In other words, much as people are saying, you'll hear debates out there, people are saying, people don't want an oversight committee over the presidency. Others are saying, of course, yes, we don't want. So we said, let's find a middle ground. We have to exercise oversight. Let's have an appreciation of which areas require that kind of scrutiny by Parliament, and then we have this team. So the team, I think, is leaving on the 17th, I think, to appear, to be there, to observe and see, because anyway, our system is a Westminster system. So we're trying, I'm saying, ENCA, even on the Meta-Year committees, because there's a recommendation there, a recommendation which says the majority of committees in Parliament should be chaired by the opposition. That's what it says. The majority of committees should be chaired. Parliament has its own internal processes and procedures. Committees have their own internal processes where the committees come together and they decide as committee, by the way, I can't even interfere as the speaker there. Then they decide who they want as the chair of that committee. So this, what I think we do not want to appear to be defensive or to be in the offensive, but we are simply stating facts as they have been presented to us by the State Capture Commission and how we have since responded to those issues. But a suggestion that nothing is being done, and which the Chief Justice also yesterday did say that he didn't say nothing is being done. But he was foreseeing a situation where in the future we may slide back to the old tendencies of not following up on some of these matters. And as I said, we clarified the issue. I think the last issue I would like to address is, somebody said CJ interprets the law. That's the point. He's the ultimate in terms of the law. He's the Chief Justice of the Republic of South Africa. So whatever the CJ says is law. And whatever the CJ says, everybody here, in the public will say, yes, yeah, the CJ is correct, okay? And that is why we said we will not be opportunistic as the legislature and want to engage a CJ in the public domain. It wouldn't have helped us. It wouldn't have been good for our democracy. It's not healthy for a democracy. So he made his statement, and we decided quietly to seek audience with him, and we explained all of these things to the CJ. And I can attest to the fact that he really appreciated the meeting and actually clarified certain things like, well, I didn't say this one, I didn't say that one. But unfortunately, we've not been able to get the statement of the CJ so that we see the context within which some of these things were said. But commission work ended last year. And there's nowhere, I repeat, where it says, at the conclusion of this work, Parliament will have an obligation to then report progress made. No. So we are not adverse to public scrutiny at all. But it also depends on who does that scrutiny. Who does that scrutiny? And how is it done? And I think that's what has put us where we are now. So we're happy, Tina, with the meeting yesterday. We think it went very, very well. We believe that the discussions were with the CJ were very cordial, respectful. I mean, there was mutual respect, clearly. And I hope that we can avoid some of these things, because we do not want to send a message to South Africans that there may be instability in South Africa. There is no instability in this country. This is a very healthy democracy where there is vibrant engagement when it is necessary to do so, and therefore no impressions should be created that there's instability in the country. The arms of the state, three arms of the state, work together. It is for that reason that the President Naye, after receiving his report, worked on a plan of action and submitted that plan of action in Parliament, because he knows that we then have to conduct oversight on the basis of what he has submitted to us. Lastly, with regards to law enforcement agencies, kaloku thina, we are not a law enforcement agency. And by the way, it was not even raised by the CJ Londole. It did not raise that. There are people who are law enforcement agencies that's under the arm of the executive and not under us. But of course, you know as well as I do that on a regular basis, the law enforcement agencies do appear before committees. They appear before the committees. They appear before the police. They appear before SCOPA to provide updates on work done by their forces. Thank you very much.